Hello and welcome to today's web seminar, the first in a quarterly series of educational transportation industry web seminars brought to you by Interstate Motor Carriers Capacity Agency LLC. Today we'll be discussing reclassification issues facing the trucking industry in a presentation titled Independent Contractor or Employee. Can't we all agree? Presented by John Kellenberger, Esquire, an attorney who specializes in the topics we'll be discussing today and has deep subject matter expertise regarding trucking industry legislation. Before we begin, I'd like to briefly discuss the technology we'll be using today. All of your lines have been muted for the duration of the web seminar. However, you can enter any inquiries that you have either the question box or chat box, and we'll answer as many as we can at the conclusion of the presentation. You can also slide the GoToWebinar box closed by clicking the orange arrow or double arrow, but do not click the black X or you will exit the web seminar. Now, without further ado, please welcome our special guest speaker, John Kellenberger. John, the floor is yours.
Good afternoon, everyone. I appreciate that introduction, John, and I thank Interstate for sponsoring this webinar. I have been a practicing transportation attorney for over 5 years. I represent motor carriers and freight brokers throughout the United States in regards to their corporate issues and some litigation matters. Since the time is short, I want to get right into it. And I can't emphasize this enough. If you take one thing out of this webinar and one thing only, it's that one size does not fit all. I think a lot of folks in the industry are under the impression that if the federal government says that your owner-operators are independent contractors, that that's the end of the analysis. Or if under the FLSA, the Federal Labor Standards Act, your owner-operators are exempt from overtime, from pay overtime, that that's the end of the analysis. And unfortunately, like in the rest of the world, our government, state and Fed, have made it more complicated on our business. So what this means is a worker who is considered an independent contractor under one area of the law is not necessarily an IC under another area of law. And examples of this is you can be considered an independent contractor by the IRS, and your state, the state that you're operating out of or the state that you have owner-operators providing services out of, may view you as may view the owner-operator as an employee. Similarly, and to make it even more complicated, in a particular state, there may be separate tests for whether or not a person is an employee for purposes of the Unemployment Tax Act and for the Workers' Compensation Act. So you can have a state that says that a person is an employee under the Workers' Comp Act and is entitled to workers' comp benefits, but is exempt from the unemployment tax because they're an independent contractor. Next slide, please. I want to briefly go over how the feds would view the employer-employee or independent contractor owner-operator relationship. I'm sure many folks here are familiar with the 20 questions test and may have had your owner-operators fill that out when you're qualifying them and keeping the file. That's a good practice to do if folks are doing that. The IRS now uses a 3-category test. In practice, it looks a lot at the same factors that the 20 questions test used. The main focus that the IRS is concerned about is still the right to control, whether or not you, as the putative employer, have the right to control the owner-operator, and whether or not that worker is independent from that control. There are a few factors. There are 3 categories that the IRS will look at, and they're listed below. There's behavioral, financial, and the type of the relationship. So specifically on the behavioral side, does the company control or have the right to control what the worker does and how the worker does his or her job? So in the context of motor carrier or freight broker relationships, this comes up most often in route guidance. So in other words, are you mandating your owner-operators to use a specific route, or are you just saying to the owner-operator, the load's got to get there by this time, and we have a suggested route for you, but you're free to use which route you choose, provided that you can get the load there in time. Financial aspects. Are the business aspects of the worker's job controlled by the payer? How is the worker paid? Expenses are reimbursed. Who's providing the tools or the supplies? Typically, the owner-operator will be paid either by a percentage of the load, occasionally by mile, typically not reimbursed for expenses that it will incur providing the service. So typically, the owner-operator will fare out well on that portion of the test. 3 types of relationships: written contracts, and employee-type benefits. Obviously, pursuant to the Federal Truth in Leasing regulations, you will have a lease with your owner-operator, which will delineate the terms of the relationship. So by law, you're always going to have a written contract. So the key issue there is the employee-type benefits, and we'll talk a little bit more about those in a second. Next slide, please. So looking at behavioral control in a little bit more detail. So one of the factors the IRS looks at, type of instructions given. So they've given us guidance that says an employee is generally subject to the business instructions about when, where, and how to do the work. And below are the examples of types of instructions about how to do the work. So when and where to do the work, what tools or equipment to use, what workers to hire to assist with the work, where to purchase the supplies and services, what work must be performed by a specified individual, and what order or sequence to follow when performing the work. Again, in our industry, in our context, you would have a situation where if you, as the motor carrier, if you had a fleet, if you had an owner-operator who had a fleet, and you were telling that owner-operator specifically what driver they are to use on a given, on a given route, that would militate more towards the employer-employee side. On the flip side, if you had an arrangement that said you can use a driver of your choice as long as that driver is qualified pursuant to the safety regulations and pursuant to guidelines, but you're not selecting the individual driver, that militates more towards the independent contractor relationship. Similarly, I would think that a lot of folks in their owner-operator contract will have a provision that says the owner-operator will provide a driver, but it doesn't say the owner-operator himself or herself has to be the driver. In terms of what tools or equipment to use, obviously pursuant to the Truth in Leasing regs, the owner-operator is going to be leasing you as the motor carrier the equipment. And again, it's going to be up to you in the context of an IRS audit to educate the auditor about the nature of the business and the nature of the fact that you're not specifying that that equipment has to be used. The owner-operator himself or herself is actually leasing it to you. Just a general point, it's very important to remember that even in the IRS context or in the state context, the vast majority of the time, the auditors are not going to understand your business. They don't understand why you have this lease agreement. They don't understand why this person is providing you equipment. And in the lease, it says that you are responsible for the equipment while it's pursuant to the terms of the lease. The auditors don't understand why that provision is in there. So you have to have experienced counsel explaining to them that, well, this is a provision that's required pursuant to the Truth in Leasing regs. It does not mean that we are controlling that owner-operator. It's just the federal government requires us, and as a matter of fact, there are cases that say that does not create an employer-employee relationship. Degree of instruction. The more detailed the instructions, the more control the business exercises over the worker. Less detailed instruction reflects less control. Again, we're talking about route instructions, or we could be talking about, in the context of safety procedures, again, we want to be educating the auditor that these are not necessarily our procedures, that these are procedures that are mandated by us, by the government. So while they may seem detailed, there's a specific reason that we have them in place. Obviously, we all want to promote safety, but moreover, these are not our internal policies. We're being forced to implement these by the government. Again, evaluation systems measures. If the evaluation system measures the details of how the work is performed, then those factors militate more towards an employee. Conversely, if it's just measuring the end result, this can point to an independent contractor or an employee. So again, we while we're conscious of safety and we're conscious of the CSA scores and all of that, we've got to be careful how we're wording that when we give any feedback or performance evaluation systems to the owner-operator. Training, the business provides the worker with training on how to do the job. This indicates the business wants the job done in a particular way. So if we have our safety meetings or other meetings as an MC, we might want to phrase those meetings as an invitation rather than as you will attend this meeting. Subtle difference, and we all know the owner-operator needs to attend those meetings anyway, but if we're kind of providing it as one business to another, because remember, that's how we want the IRS to view it. The MC is an independent business, the owner-operator is an independent business just doing business with each other. We want to be careful with how we phrase those invitations. Next slide, please. Financial control, significant investment. The independent contractor often has a significant investment in the equipment that he or she is using. Obviously, the owner-operator will be either owning the equipment, will be financing the equipment. Things to look out for, and we'll get into that. We'll get into it into a little more detail in a second. Whether or not you, as the MC, are providing a lease-to-own or financing program through an affiliated entity. Absent that circumstance, it's pretty easy to show that the equipment is expensive, tractors, and if the owner-operator owns the trailer. And you just establish to the auditor that this is equipment that is owned by the independent contractor, the owner-operator, in connection with his or her business. Unreimbursed expenses. Independent contractors are more likely to have unreimbursed expenses than our employees. Fixed ongoing costs that are incurred regardless of the work, of whether the work is currently being performed, are especially important. So it's important to educate the auditor that no matter what happens, that owner-operator has to make those lease payments. That owner-operator, if it's a fleet, has to pay the unemployment tax on the workers, has to pay workers' comp if that's applicable. Those expenses are not going to go away if the owner-operator stops performing the services for a week. They're fixed, and it's important that the auditor on the IRS side is made aware of that. Opportunity for profit or loss. I'm sure those of you on the MC side are aware that of certain owner-operators who manage their costs and expenses more efficiently, and then some owner-operators who do so less efficiently. And it should be relatively simple to be able to show an auditor how two owner-operators could gross $100,000 but have vastly different profits or take-home pay at the end of the day based on how they're managing their expenses. But that has to be illustrated to the auditor. It has to be shown to the auditor that the owner-operator has real risk. These are real expenses that they have to manage. Similarly, the owner-operator, the more volume they do, the more gross pay that they're going to have. Again, educating the auditor of all these factors. Services available to the market. An independent contractor is generally free to seek out business opportunities. What we want to show there is provisions in the lease that allow the owner-operator to terminate, and you will have, typically a provision that says the lease agreement is valid for 3 months or for a year unless terminated by the parties. And you just have to explain to the auditor how the escrow system works, that the escrow is not a penalty. But again, the idea there is that the owner-operator can leave at any time, and the MC is free to term them at any time. Method of payment. Again, this factor usually militates towards an independent contractor status because the owner-operator is typically paid weekly through settlement, and the owner-operator is paid typically a percentage of revenue on the trip. Next slide, please. Type of relationship. We already talked about the written contract. Typically, you'll have in your lease agreement with your owner-operator that the parties intend to have that the relationship be deemed as an independent contractor relationship. That is not binding on the IRS. That is not binding on state court. However, I strongly encourage you to have that provision in there, as there's a significant amount of case law that does look at that as a factor. What did the parties intend? The IRS has a carve-out there saying they're not obligated to follow it, but they do look to that. It also can prevent the owner-operator in certain instances from coming back and saying, no, actually, I thought I was an employee. It's harder to make that statement when in the lease agreement they're acknowledging that they want it to be an independent contractor. Employee benefits, what I see as issues with a lot of my clients is they have a particular owner-operator or group of owner-operators that they've been providing health benefits or retirement benefits or some form of sick days over a long period of time. Typically, businesses do not provide benefits to other businesses that they're doing business with. So if you have those types of programs, the IRS views that as more of an employer-employee relationship. So you want to scrutinize whether or not your owner-operators are receiving any of those types of benefits, and then figure out whether or not the risk of giving those benefits is worth it. Permanency of the relationship. If you hire a worker with the expectation that the relationship will continue indefinitely rather than for a specific period of time, it's generally considered to create an employer-employee relationship. Well, again, the lease agreement typically will be terminable at will, provided that the owner-operator and the motor carrier fill out specific conditions. So it's not an indefinite term. So therefore, you can use the lease agreement to show the auditor that there is a specific period involved. Services provided as key activity of the business. This is a difficult factor to establish because the owner-operator will always be providing services that are key aspect to your business. Again, I stress it's very important to have experienced counsel, whether it be an accountant or an attorney, to explain to the auditor exactly how you're doing business. Next slide, please. How can these issues come up? Well, a couple of scenarios on the federal side. Number one, the owner-operator itself is audited and has significant liability for employment taxes. They haven't paid tax in a while. And when they're faced with that liability, they have some incentive to come back and say to the IRS, well, actually, I was really an employee, and here's why. Second context could be an IRS audit. The IRS as an entity are seeking a reclassification determination from your entity. The third and most troubling at this point is the state audit. So if a state comes in and says, we think XYZ Trucking is actually employing these owner-operators, there is a memorandum of understanding that has been executed between various states, the federal IRS, and the Federal Department of Labor. And you can skim through what the memorandum of understanding says, but the important thing is this quote: the memorandum of understanding will enable the U.S. DOL to share information and coordinate law enforcement with the IRS and participating states in order to level the playing field for law-abiding employers and ensure that employers receive the protections to which they're entitled under federal and state law. This is a huge area of emphasis right now with all of the state departments of labor and with the Federal Department of Labor and the IRS. The coffers are depleted on the unemployment side, and they are looking to gain revenue to build those coffers back up, and this is the low-hanging fruit. So be aware that if the State Department of Labor comes in to look at you, depending on what state you're in, they are likely to communicate with the IRS and the Federal Department of Labor any information that they receive in regards to your business. Next slide, please. Just a few federal items. Just number one, and I can't stress it enough, take it seriously. A lot of times folks think, no, we've been considered an independent contractor for years. We won't have any liability here. There are significant penalties and interest and employment tax liability. So the minute that you receive correspondence from any federal agency in regards to this, I strongly encourage you to speak with experienced counsel or speak with your accountant. Get them involved right away. The auditors are trained to be friendly. They're trained to just ask innocuous questions, but you have to view those questions towards what their ultimate goal is, and that's a reclassification. Always keep in mind Section 530. That prevents retroactive reclassification if you can establish certain factors, basically that you were treating the workers as independent contractors consistently, that you were filing 1099s for those workers for the tax years at issue, and that you had a reasonable basis for treating the workers as independent contractors. you should be able to establish that you have a reasonable basis based on a lot of the IRS precedent. The IRS in the past has issued revenue rulings which indicate they understand the way that you're doing business and they understand that these folks are independent contractors. Section 530 has been under attack from the Obama administration and Congress over the last couple of years, so it may not be applicable by the time if you do or if you are unfortunate enough to be audited, but always just make sure you speak with your professional who's representing you about that possibility because it can avoid retroactive penalties. The IRS is obligated to bring it up if they are auditing you, but they don't always. Briefly, the SS8 forms are the forms that the employer or the employee can file with the IRS to seek a determination. So you can proactively seek a determination of an independent contractor status. I don't always encourage this because you're bringing yourself to the attention of the IRS, but in certain cases, in the state context, which we'll talk about in a minute, it may be beneficial to do so. Next slide, please. Real quick on the state law issues, as we've touched on, the federal decision on status, employment status, is not binding on a state's decision. Just because the feds say somebody's an employee does not mean the states have to follow that. Moreover, a state decision in one context on employment does not dictate the state decision in the other context on the workers' comp. So I'm going to go over real quick a few of the statutory exemption that common law tests for the unemployment and workers' comp side. Next slide, please. Here's an example of a statutory exemption that's currently in place in the state of New Jersey for the unemployment side. So basically, if you look at this test, it looks pretty easy, and you would think that any motor carrier who has owner-operators can meet it. It basically says that if you're providing services which are exempt from FUTA, you're operating a motor vehicle with excess of 18,000 gross vehicle weight, licensed for commercial use, used for highway movement of motor freight. The owner-operator owns the equipment or leases or finances it through an entity unrelated to the motor carrier and is compensated by receiving a percentage of the gross revenue. They are presumptive independent contractors. So that seems easy to establish based on most motor carriers' business models. Well, not so fast. The issue with the New Jersey Department of Labor is how do you prove services are exempt from the Federal Unemployment Tax Act? So what in the past was a simple matter of showing them that the owner-operators were exempt using the 20-question test. Now, practically speaking, the New Jersey Department of Labor has required that motor carriers go to the IRS and get revenue rulings or private letter rulings in terms of their owner-operators. This is a cumbersome process. It can take months. You're then bringing yourself to the attention of the IRS, and the IRS is going to look at how you're doing business. So difficult. It seems on the face easy to satisfy. In practice, difficult. Again, remember, this test does not apply to workers' comp in New Jersey. There's a separate test, so you cannot rely on this exemption on the workers' comp side. Next slide, please. Georgia has a workers' comp exemption, which basically says that any owner-operator is not an employee under workers' comp, and they defined owner-operator as an equipment lessor who leases his vehicular equipment with a driver to a motor carrier. Sounds really easy, right? I mean, basically, we can all fit under that exemption. Not so fast. If you have a fleet if you have a fleet owner-operator, and that fleet owner-operator has employees, and that fleet owner-operator does not provide workers' comp, this exemption does not apply to you as the motor carrier. There are statutory employer protection provisions in the Georgia Code. So in that scenario where you have the employee of the fleet owner-operator, he can reach up and get the motor carrier, and the motor carrier will be liable for workers' comp, and the exemption will not apply. So again, if you are relying on these statutory exemptions, make sure you speak with experienced counsel who understands your business and who can explain these little nuances to you. Next slide, please. Real briefly, the common law tests that are used on the workers' comp or on the unemployment side, right of control. We've talked about that. Does the motor carrier determine the daily details of the owner-operator's duties? Modified right of control, that's a right of control, also asking whether or not the owner-operator is engaged in an independent business. Nature of the work test, which is almost impossible for any motor carrier to pass. That would mean that the owner-operator's work is sporadic and incidental. Very unlikely that you can pass that test. And then there's an agency test where you have about 9 factors that the relevant Department of Labor will look at. Next slide, please. There's also the famous ABC test. That's, again, dealing with control and direction. The thing to look at is factors B and C and the, quote, source of revenue rule. What a lot of states have said is that if you have an owner-operator who's generating 100% of their revenue from one entity, that owner-operator is an employee because all their revenue is generated from that one entity. That's a difficult proposition to defend against if your owner-operators are just serving you in a year. Next slide, please. New Jersey State Bill 1450 is an example of reclassification efforts by the states. It's just one example. The reclassification effort is running rampant throughout the country in the trucking side and generally in other industries as well. Just a quick rundown of what the SB 1450 does. Creates a presumption of employment for all drayage drivers in the state of New Jersey. Interestingly enough, the statute provides labor unions the ability to bring lawsuits against, quote, employers who don't classify properly, even if the union doesn't have an involvement with the employer. It's given the union legal standing, so it's giving them an incentive to bring that suit, even if they have nothing to do with your business. There's class actions, there's attorney's fees, there's criminal penalties for misclassifications, which you can see here, and there are significant civil penalties. This bill is currently tabled right now between the Senate and the Assembly. Some of my clients have been engaged in a lobbying effort against the bill. We're continuing in with that effort. We feel pretty optimistic about that the bill will be stalled. But you need to be aware that these bills are out there in every state that you're operating in, and even if you don't have if you don't have an office in those states, if you are engaging owner-operators that are providing services in those states, you need to look at these bills. Next slide, please. I'm going to quickly go over a few suggestions that I have to deal with these reclassification issues. These are not state-specific, and again, I encourage you to speak with counsel or your accountant in regards to your specific state issues. Number one, the owner-operator should be legally organized as a separate entity, or if the owner-operator's DBA, have a separate FEIN. And to the extent possible, require proof that the owner-operator is paid or a fleet has paid their self-employment taxes, workers' comp if that's applicable. Same thing with a fleet driver. You want to have proof that those payroll and unemployment taxes have been paid. This helps you in 2 ways. Number one is pretty persuasive proof that you're not the employer. Number two, it kind of alleviates the possibility that that during the audit of a owner-operator, he's going to turn around and now say he's an employee because you know those taxes have been paid. Strictly analyze lease-to-own and financing arrangements. So to the extent you as the motor carrier are offering those programs, some states have provisions which automatically reclassify owner-operators if the MC or an affiliate is providing the financing or has a security interest. So look through your programs and be aware of what the state law says about those. Similarly, non-competes in your owner-operator agreements. Some states have provisions that if there is liability for competing with the MC after termination of the agreement, it's automatic reclassification because that person is not independent to leave. That person can't leave without liability. So look at that. Look to see if the owner-operator is providing services for any other entities in a specific year. If he is, ask to see their 1099s for those. Have them in the file. Next slide, please. Require the owner-operator to submit business cards and letterhead using his trade name. Similarly, have him submit invoices for payment in the name of his business. The MC, we want to always keep the context that the MC and the owner-operator are separate businesses doing business with each other. You're not employing that driver. The driver owns a business. The owner-operator has a business. You have a business, and you're contracting with that business for service. You should, as we've discussed, have control only over the results to be obtained, not the means to secure those. And then all these are, to the extent possible, the owner-operator should bear some financial risk for losses due to their negligence and should be able to meaningfully negotiate rates or fees. That's not always possible in the motor carrier business. Sometimes your model is we just pay a certain percentage. But to the extent that you do negotiate those out with your owner-operators or fleets, give that information to your attorney. That's valuable information in a reclassification action. And you could have signage on your vehicles as outlined here, very small disclaimer language, independent contractor under contract with the MC. This will ensure that the owner-operator can't say, that a third party can't say that the owner-operator was holding themselves out as an employee of the motor carrier. And the final slide is, in regards to questions or straight to the bar. The reason why I have straight to the bar up there is I have a very, very good client of mine who every time I speak to him about these issues, he tells me it's bourbon time and that he's going to the bar. And I just caution you that when the attorneys tell you these things, we don't write the laws. We're business owners as well. We don't like these laws. So if you have a proactive strategy and you're speaking with your attorneys, the attorney is not always the bad guy. The attorney is actually trying to help you mitigate these risks, even though he's often giving you bad news, as I've outlined today. So without further ado, if there are questions, I'll be happy to grab them. I don't know how we're doing on time, John.
Well, thank you very much, John. We have gone through our 30-minute web seminar time frame. However, we will leave a Q&A open for a few minutes. We want to thank you for this very informative presentation. Many questions are coming in as we speak. During the Q&A, I'm also going to open a poll. Anybody who would like to speak with Interstate Motor Carriers about this topic, other transportation industry topics, or their insurance needs may request an appointment or more information from Interstate. And with that, we'll get right into the first question. The first question we have is, how is providing loans to individual owner-operators viewed within this issue?
Very good question. And what I would say is, if you are going to provide loans to your owner-operators, you want to document those loans, and you want to be charging interest. Businesses that are dealing with other businesses typically do not just give loans with no interest. So, and the interest has to be a meaningful interest rate. You don't want the Department of Labor to be able to have an argument that you're subsidizing that loan by virtue of your relationship. So I would say, generically, loans can be given, but documented with an interest rate.
Thank you, John. The next question we have was actually asked by several people about today's PowerPoint presentation. If anybody would like a copy of the PowerPoint, please contact Craig at Interstate. His contact information will be back on the screen in just a moment when we close the poll, and he can help you with that. Next question we have is, do we have to include owner-operators under Obamacare?
That's actually a great question. In terms of whether or not you have to include them, it's whether or not they fit under the definition of employee. So we go back to these tests. I don't pretend to be an expert in the healthcare Act, but what I would say is you'd go back and look at whether or not your folks can be considered employees, and whether or not then you're subject to providing them access to it. You should be wanting to take the position that they're not, and I think the IRS and various other guidelines have shown that they're not. And if you're running your business typically through an owner-operator model, they wouldn't be. But that frankly, I would encourage you to also speak with counsel who's an expert in healthcare as well. I don't want to give healthcare advice.
Thanks, John. The next question we have is, we hold a bond or escrow for our owner-operators. Do we need to pay interest for that escrow?
Yes. Well, I believe that under the Federal Truth in Leasing regs, you have to pay interest on that. I believe there's a specific regulation that talks about that. So, yes, I would say that, first of all, it depends on, what your leasing agreement says. You should definitely be following your leasing agreement. I think the Federal Truth in Leasing regs require it, and I think as a matter of course, it would be a good idea to be providing interest on it, just from the standpoint of, again, establishing the independence of the parties.
And unfortunately, we are running short on time. We'll squeeze in one last question. We appreciate everybody for attending today. Had a very large audience and many, many questions that we're not going to have time to get to. Is there any issue for brokers who have dedicated carriers who are independent contractors, in parentheses, one-truck operations?
Excellent question, and yes, there are. Brokers can be the subject of reclassification actions. The tests that you would look at are similar to the test, or identical, I should say, to the test that I presented. So you would look at under the state law. You would be looking at those 4 tests that I provided, whichever test that your state uses. On the federal side, we would be looking at the 20 questions as boiled down into the 3 factors as outlined in the presentation today. But yes, it is possible, and I have heard of brokers being the subject of reclassification audits.
Well, once again, I'd like to thank you, John, for the excellent presentation today. We'd love to thank Interstate Motor Carriers Capacity Agency for sponsoring this web seminar and bringing this great educational content to the trucking industry. And last but not least, thank you once again, all of you, for attending. This web seminar is now ending. We hope you have a great day.